morning. It's my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is February 12th, a Wednesday, 9:30 a.m. With us today are Commissioners Emily Lindley and Bobby Janeka. I'm John Neerman. Our General Counsel, Mary Smith, will call the first item.
Item number 1 is consideration of the ALJ's proposal for decision and proposed order assessing administrative penalties against Doug Calhoun doing business as Bubba's Scrap and Junk Removal. Presentation should begin with the ED, followed by the respondent, and then OPIC. By letter dated January 24th, 2020, the Office of Chief Clerk provided each of the parties with 5 minutes of oral argument time in accordance with the Commission's standard practice. The ED may save time for rebuttal as he bears the burden of proof. The Executive Director is here to present.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Jess Robinson with the Litigation Division. With me today are Jaime Martinez with the Houston Regional Office and Epifanio Villarreal with the Enforcement Division. This administrative enforcement case involves a property where the respondent conducted business activities and where he burned waste in a pit. The ED alleges the respondent caused, suffered, allowed, or permitted outdoor burning and the unauthorized disposal of municipal solid waste. And the ED recommends he pay an administrative penalty. In her proposal for decision and proposed order, the ALJ found that respondent committed the violations as alleged and recommended that he be ordered to pay a penalty of $2,442. After the ALJ issued her proposal for decision and proposed order, the ED submitted exceptions to the proposed order. In her letter responding to the exceptions, the ALJ recommended sustaining the exceptions regarding errors. The ED respectfully requests that the Commission adopt and issue the ALJ's proposed order as amended by the ED's exceptions. We are here to answer any questions you may have, and we would like to reserve the remainder of our time for rebuttal if necessary.
Thank you. I have no questions at this time. Colleagues?
No questions, thanks.
None. Is Mr. Calhoun here? I don't see him. OPIC.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. OPIC agrees with Judge Smith's conclusion that the Executive Director proved by preponderance of evidence that respondent committed the 2 violations as alleged in the Executive Director's preliminary report and petition. Further, OPIC notes that the parties stipulated that the proposed penalty, as recommended by the Executive Director, was calculated consistent with the Commission's penalty policy. Therefore, OPIC agrees that the penalty recommended by the Executive Director is reasonable and correctly calculated in accordance with applicable statutes, agency rules, past agency practice, and the TCEQ penalty policy. Finally, OPIC agrees with the recommendation of the Executive Director that the payment of the administrative penalty will resolve this case and that no further corrective actions are necessary. Therefore, OPIC respectfully recommends that the Commission adopt Judge Smith's proposal for decision and proposed order, and as recommended by Judge Smith, sustain and incorporate 3 of the 4 changes requested by the Executive Director in his October 15, 2019 exceptions to the Judge's proposed order. Thank you, and I'm available for any questions.
Thank you. Colleagues, I don't see any reason to upset what the ALJ has done here. I think the PFD is appropriate. As for the exceptions, I would adopt the order with all of the Executive Director's exceptions, and wanted to gather your thoughts on
I'm in agreement. Yeah, I agree with everything you said.
Likewise. I'll entertain a motion.
I move that we adopt the ALJ's proposed order with the modifications recommended in the ED's October 15, 2019 exceptions.
I second that.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 2 is the consideration of the ALJ's proposal for decision and order regarding an enforcement action against R&K LLC doing business as Discount Self-Serve 2. Presentation should begin with the Executive Director, followed by the respondent and the Office of Public Interest Counsel. By letter dated January 24th, 2020, the Office of Chief Clerk provided each of the parties with 5 minutes of oral argument time in accordance with the Commission's standard practice. The ED may reserve time for rebuttal as he bears burden of proof. And the Executive Director is here to present the item.
Good morning.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. My name is Taylor Pearson with the Litigation Division representing ED. With me today is Steve Williamson, an investigator with UTA, and Thomas Clark with the Financial Administration Division. This case involves 3 violations of the petroleum storage tank rules at a facility operated by R&K LLC. During an investigation, Mr. Williamson documented that respondent failed to provide corrosion protection for the UST system, failed to monitor the USTs for releases, and failed to provide release detection for the pressurized piping associated with the UST system. At the evidentiary hearing, respondent stipulated that it committed the violations and that the penalty was calculated correctly. The sole contested issue was respondent's financial inability to pay claim. In his proposal for decision, the ALJ found that the respondent committed the violations, the penalty was correctly calculated, and that respondent should comply with the corrective action requested by the ED in accordance with the joint stipulations. In light of all the evidence and testimony presented at the hearing, the ALJ found that respondent did have the ability to pay the $9,124 penalty. Because TCEQ's financial analyst evaluated the respondent's ability to pay the penalty over a period of 3 years, the ALJ recommended that the Commission consider a payment plan. The ED concurs with the Administrative Law Judge's proposal for decision and recommends adoption of the proposed order and the inclusion of the ED's exception, which is intended only to clarify the order and correct one minor typographical error. We are here to answer any questions you may have.
Thank you. I have none. Colleagues, any questions?
None for me.
And I understand that there's a manager here for R&K, but that he does not wish to address the commission. So this is the opportunity for the respondent. We'll now hear from OPIC.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Dominique McLegan-Brown with the Office of Public Interest Counsel. OPIC agrees with the ALJ's decisions that the penalty recommended by the ED is reasonable and calculated in accordance with applicable statutes, agency rules, TCEQ penalty policy, and past agency practice. OPIC acknowledges that the only issue in dispute is respondent's inability to pay. Furthermore, OPIC agrees with the ALJ's conclusion that respondent failed to show that a lower penalty was justified based on financial circumstance. OPIC also agrees that because TCEQ analyzed respondent's ability to pay over a 3-year period, a payment plan is appropriate. Therefore, OPIC recommends that the Commission adopt the ALJ's proposal for decision and issue a payment plan for the administrative penalty. Thank you.
Thank you. Colleagues, any questions or comments?
No, thank you.
All right, so again, we're not in a position to substitute our judgment for the ALJ's judgment. The ALJ is in the position to judge the evidence, and they've done so. There's no reason for us to upset that. I propose that we go ahead and adopt the PFD with the 3-year payment plan included and the exception that was noted.
I'm comfortable with that.
I'll entertain a motion.
Ready to do that. I would move that we adopt the Administrative Law Judge's proposed order with the modifications recommended by the Executive Director's exceptions and agreed to by the Administrative Law Judge's reply dated November 1, 2019, with the following changes. Replace 335.50B1A and B2 with 335.50B1A and B2 in findings of fact 10 and 11. Let me restate that just so I'm correct. Replace 335.50B1A and B2 with 334B1A and B2 in findings of fact 10 and 11. Replace Texas Water Code 26.3475D and C1 with Texas Water Code 26.3475A, C1 and D in Conclusion of Law 8. Revise Conclusion of Law 16 so that it states, the corrective actions to which the ED and respondent stipulated conform to the requirements of the Texas Water Code and Texas Administrative Code and are appropriate, and authorize a 36-month payment plan for the administrative penalty in ordering provision number 1.
Oh,
One more clarification. Third time's a charm for the first correction that I recommended, the following change. Replace 335.50B1A and B2 with 334.50B1A and B2 in findings of fact 10 and 11, and the other 3 changes as previously described.
I second.
The motion has been made and seconded. And our lawyer is okay with it. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you.
Thanks.
Item number 3 is consideration of whether to affirm, modify, or set aside the emergency order renewing the appointment of a temporary manager for the public water system owned and operated by Castle Water Incorporated. The ED should speak first as the movant, followed by the respondent if present. Hearing requesters, presently none are signed in. The temporary manager if present, and then OPIC. The Office of General Counsel recommends a 5-minute limit on each party's presentation. And the Executive Director's staff is here to present.
Good morning.
Good morning, Chairman, Commissioners, Public Interest Counsel, and General Counsel. Excuse me. My name is Adam Taylor, and I represent the Executive Director with the Litigation Division. With me today is Jaime Garcia, also the Litigation Division, Adriana Thomas of the Water Supply Division, and Crystal Watkins of the Dallas-Fort Worth Regional Office. Item 3 is the emergency order renewing the appointment of a temporary manager of the Horseshoe Bend Water System, owned and operated by Castle Water Incorporated. The circumstances that led to the issuance of the first emergency order is as follows. On November 2nd, 2018, TCEQ referred Castle Water to the Office of the Attorney General for civil enforcement, including the appointment of a receiver. Then, on June 17th, 2019, 17 days before the first emergency order was issued, TCEQ began receiving complaints regarding the water utility. TCEQ received multiple complaints that the water utility was not providing water for 12 out of those 17 days. In addition, TCEQ documented that the water utility did not have a licensed operator, that they failed to maintain the disinfectant chlorine residuals, that the chlorine canisters at the pump station were marked full but were actually empty, that 2 of the wells were no longer producing water, and that for 16 of those 17 days, they failed to provide the regulatory minimum pressure of 35 pounds per square inch in the distribution system. In short, the water utility was abandoned because of these numerous issues, all of which pose significant health hazards to the 1,700 customers it serves. Because of this, on July 3rd, 2019, the Executive Director issued the first emergency order appointing Mr. Patterson as the temporary manager for the water utility. Furthermore, on September 17th, 2019, the Office of the Attorney General filed the receivership petition in district court. During Mr. Patterson's first 180 days, he replaced a well pump and motor, replaced and repaired the chlorination equipment to provide proper disinfection, installed a cellular monitoring system to improve operator notifications, and repaired 13 main distribution line breaks. On December 30th, 2019, the Executive Director issued this emergency order and reappointed Mr. Patterson as temporary manager of the water utility. The water utility is currently providing continuous and adequate service to the customers, and no complaints have been received since Mr. Patterson was appointed. The Executive Director respectfully requests you affirm the December 30th, 2019 emergency order with the modifications recommended by the Executive Director to correct minor typographical errors. We are available to answer any questions you may have.
Thank you. I have none. Colleagues, any questions?
No, thank you.
Is there anyone here from Castle Water who wishes to address the commission? Mr. Patterson, do you wish to address the commission? We'll turn to OPIC.
OPIC recommends approval of the order affirming and modifying the emergency order renewing the appointment of Mr. Patterson as temporary manager of Castle Water, Inc. as presented by the Executive Director.
Thank you. I agree. Mr. Patterson, I don't believe you're here, but I appreciate Mr. Patterson's returning this system to operation and for his continued willingness to serve. I think the order is appropriate and that we should move forward with it.
I agree. I move that we adopt the ED's proposed order modifying and affirming the December 30th, 2019 emergency order reappointing Mark Patterson as temporary manager for Castle Water Incorporated.
I second the motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
That takes us to the enforcement docket, which is items 4 through 32. Item 11 was remanded at the request of the executive director. On item 6, we have 2 individuals who have signed in and indicated that they don't wish to speak unless the commission has questions, and their presence will be noted for the record. On item number 7, we have somebody signed in who wishes to address the commission. The executive director's staff is here to present the matters.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Janice Hernandez, and I'm the Agenda Coordinator for Litigation. With me today are Gitanjali Yadav, also of the Litigation Division, and Brian Sinclair and Melissa Cordell of the Enforcement Division, representing the Executive Director. Pending before you are items 4 through 10 and 12 through 32. The total assessed administrative penalties are $586,285, with $103,283 deferred, $116,873 applied towards supplemental environmental projects, and $366,129 to the general revenue. The Executive Director respectfully requests approval of these items, and we are available to answer any questions you may have.
I have none at this time. Colleagues, any questions?
Likewise.
Okay, is Ms. Frazier here to address item 7? I think we have you signed in, but Catherine Frazier, no? Okay, we'll hear from OPIC.
My office reviewed these orders and we recommend approval of them as recommended by the Executive Director.
I agree with that. Colleagues, any other questions or comments?
I'm in agreement as well.
Same.
I'll entertain a motion.
I would move that we, make sure I'm looking in the right place, would move that we adopt items 4 through 10 and 12 through 32 as recommended today by the Executive Director.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries.
Item number 33 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present the item.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair, also of the Enforcement Division, and Gitanjali Yadav and Janice Hernandez of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2020 through December. There were 512 effective administrative orders issued, and of those, 61 contain supplemental environmental projects. These orders assessed a total of $5,353,280 in penalties, with a payable amount of $3,213,885. $1,341,495 are to be paid toward supplemental environmental projects. 5,093 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 557 enforcement action referrals have been received. There are 1,609 pending administrative orders with 132 cases that are on the backlog. 198 cases are pending at the Attorney General's office for representation in district court, and 6 judgments have been issued. 1,953 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2018, 19, and 20. We are available to answer any questions you may have.
Thank you. I don't have any questions. I did want to thank you, however, for responding to the question that I had at last month's enforcement report about why the assessed penalties had ticked up. And for the benefit of those who are listening, it was a coincidence of 7 orders that were finalized in November of last year, and all told, they added up to about $1.3 million in administrative penalties. So that's why we saw that figure 4 sort of jump up. Thank you for the report. I don't have anything else, colleagues.
No questions.
Mr. McWhirter?
Thanks, I have no questions either.
Thank you.
Item number 34 is the publication of and hearing on the repeal and amendments to 30 Texas Administrative Code, Chapter 7, regarding the Memorandum of Understanding between the Texas Commission on Environmental Quality and the Railroad Commission of Texas. The Executive Director's staff is here to present this item.
Good morning, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I'm Todd Gallagher with the Environmental Law Division. And with me today are Diane Goss, also with the Environmental Law Division, and Laurie Fleet from the Water Quality Division. This proposed rulemaking would be one of several steps necessary to implement House Bill 2771 from the 86th legislative session. The proposed rulemaking will also implement House Bill 2230 from the 84th session. House Bill 2771 requires the TCQ to submit a delegation request to the EPA seeking authority for the TCQ to issue TPDES permits for discharges of produced water, hydrostatic test water, and gas plant effluent into water in the state. House Bill 2230 allows the TCQ to authorize by individual permit, by general permit, or by rule a Class 5 injection well for the disposal of non-hazardous brine or drinking water residuals in a Class 2 well permitted by the Railroad Commission. The proposed MOU would implement the dual authority granted by House Bill 2230. The proposed rulemaking would repeal 30 Texas Administrative Code, Section 7.117, which adopts by reference the Memorandum of Understanding between the Railroad Commission and the TCQ, which is currently found in the Railroad Commission's rules at 16 Texas Administrative Code, Section 3.30, and would propose the full text of the MOU between Railroad Commission and the TCQ under a new Section 30 Texas Administrative Code, Section 7.117, with changes needed to implement the transfer of responsibilities relating to certain discharges from the Railroad Commission to the TCQ and the dual authorization of Class 2 and Class 5 injection wells. At their open meeting on February 11th, 2020, the Railroad Commission adopted the proposal of substantively identical rule changes in the rules. Staff respectfully request approval for the publication of and hearing on the repeal and simultaneous proposal of new Section 7.117. Staff also requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available for any questions.
Thank you. I have none. Colleagues, any questions?
No, I would just thank staff for their work on this so far, and if anyone from the Railroad Commission and, YouTube land is listening in, thank them for their efforts as well on moving this forward, so.
Mr. McWhorter.
OPIC recommends approval for publication of and hearing on the proposal relating to the Commission's Chapter 7 rules and the MOU with the Railroad Commission, so the Commission may receive and consider public comment.
Thank you. And Commissioner Lindley, I agree. I appreciate the great work by our colleagues at the Railroad Commission and the great work by staff in pulling this together. And I think we're ready to put it out for comment.
I move that we approve the publication of and hearing on the proposed amendments to 30 Texas Administrative Code, Chapter 7, as recommended by the Executive Director.
I second that motion.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries.
Item number 35 is the consideration of the publication and hearing on the proposed amendment to 30 Texas Administrative Code, Section 342.26, regarding regulation of certain aggregate production operations. And the Executive Director's staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Shelby Williams with the Water Quality Division, and with me this morning is Michael Parr of the Environmental Law Division and Lori Fleet of the Water Quality Division. The proposed rulemaking would amend 30 Texas Administrative Code, Chapter 342, Regulation of Certain Aggregate Production Operations, or APOs, to implement changes to the Texas Water Code made by House Bill 907 from the 86th Legislative Session. HB 907 amended Texas Water Code, Chapter 28A by increasing the investigation frequency of all APOs in the first 6 years of registration, allowing unannounced periodic inspections at APOs issued a notice of violation, clarifying the training requirements for TCQ investigators, increasing the maximum penalty for each year an APO operates without a registration, increasing the maximum total penalty for APOs operating 3 or more years without a registration, and increasing the maximum annual registration fee from $1,000 to $1,500. The proposed rulemaking would amend Chapter 342.26, which currently sets the maximum annual registration fee for APOs at $1,000. The proposed rulemaking would replace the monetary amount of $1,000 with the phrase, "the amount specified in the Texas Water Code, Chapter 28A," to provide consistency as well as compliance with future legislation. Staff respectfully request approval for the publication of and hearing on the amendment to Chapter 342. Staff also requests permission to make non-substantive revisions to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you. I have none. Colleagues, any questions?
No questions.
OPIC recommends approval for publication of and hearing on this rulemaking proposal to implement House Bill 907 as presented by the Executive Director.
I agree. Colleagues, I think this is fairly straightforward legislative implementation, and am prepared to entertain a motion.
I'd love to make the motion. I just have to add, I'm very glad to see that staff is adopting facts by reference rather than prescriptive specificity and rules. I think that's where appropriate, far preferable in terms of trying to increase how responsive we are to future changes without needing to hold the public up as we resume rulemaking again. I think it's a good approach. Commend y'all on that. And I would move that we approve the publication on and hearing on the proposed amendment to Section 342.26 of 30 Texas Administrative Code, Chapter 342, as recommended by the Executive Director.
I second.
And Commissioner Janek, I appreciate that comment. In addition, it's less wear and tear on us, so a lot of good reasons to do it the way we did. The motion has been made and seconded. All those in favor say aye.
Aye.
Aye. The motion carries. Thank you.
That takes us to items 36 through 41, the quadrennial rule reviews for Chapters 7, 36, 70, 210, 285, and 294 of the Texas Administrative Code, Title 30. The Executive Director's staff is here to present.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Patricia Duran with the General Law Division, and with me this morning is Robert Martinez, Acting Deputy Director of the Office of Legal Services. Pending before you items 36 through 41, the adopted rule reviews of 30 TAC Chapters 7, 36, 70, 210, 285, and 294. As required by Texas Government Code Section 2001.039, Executive Director's staff conducted rules reviews of these chapters to determine if the need for the rules within these chapters continue to exist. Proposed notices of the reviews for 30 TAC Chapters 7 and 70, published in the August 30th, 2019 issue of the Texas Register, 30 TAC Chapters 36 and 210, published in the September 13th issue of the Texas Register, 30 TAC Section 285, published in the September 27th issue of the Texas Register, and 30 TAC Chapter 294, published in the September 6th issue of the Texas Register, with a 30-day comment period for all chapter reviews. No comments received during the public comment for these reviews. Based on the reviews of these chapters, the Executive Director has determined that the reasons for the rules in Chapters 7, 70, 210, 285, and 294 continue to exist. Additionally, during the course of these reviews, the Executive Director determined that the following are obsolete and no longer needed and will be addressed in separate rulemaking actions. 30 Texas Administrative Code Section 7.101. Because Section 7.101, subsection D, provides that the Memorandum of Understanding between the Texas Natural Resource Conservation Commission, which is TCEQ's predecessor, and the Texas Department of Commerce, the Memorandum of Understanding expired on August 31st of 1999 unless extended, which did not occur. 30 Texas Administrative Code Chapter 36. The rules in this chapter were invalidated by the courts and have been unenforceable since 2016. Furthermore, the rules are not needed because the Commission has the authority to respond to senior priority calls under TCEQ's general jurisdiction over the enforcement of water rights in Texas Water Code Section 5.013, subsection A, paragraph 1, and specify authority to issue administrative orders for water right violations under Texas Water Code Section 11.0842. In conclusion, we respectfully recommend approval of the adoption of the rules reviews of 30 TAC Chapters 7, 36, 70, 210, 285, and 294. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, project managers and attorneys assigned to these chapters available to answer any questions you may have.
I have none. Colleagues, questions?
No questions.
Mr. McWhirter.
OPIC recommends approval of these items as presented by the Executive Director.
Colleagues, since staff identified outdated provisions in Chapters 7 and 36, I'll move that we adopt the rule reviews and re-adopt the rules in 30 Texas Administrative Code Chapters 7, 36, 70, 210, 285, and 294 without amendment, and direct the Executive Director to initiate rulemaking to eliminate the obsolete sections identified by the Executive Director in 30 Texas Administrative Code Chapters 7 and 36 before the next quadrennial rules review of those chapters.
A second.
The motion has been made and seconded. All those in favor say aye.
Aye.
The motion carries. Thank you.
Item number 42 is the public comment session. Currently, we have no one signed in to speak. So that takes us to the end of the items posted for open session. The commission will meet in closed session in room 211S in Building E in 10 minutes, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 551.074, to take up and consider matters pursuant to items 43 through 46 as posted and noticed.
The time is 10:05 and we stand in recess.
The commission met in room 211S, Building E, for closed session from 10:10 a.m. until 10:28 a.m. on items number 43, 44, and 45, as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken.
The time is 10:31 and we are adjourned.